What is a security? Well, according to the Supreme Court in the landmark Howey decision, a security has four characteristics. It is a financial investment in a common enterprise that depends on the efforts of others to succeed, and it is all motivated by the desire to make money, the profit motive. Okay, now that we've learned what a security is, let's look at what the Uniform Securities Act says, specifically are securities. We list them all here, but just know that for the exam, you just really need to memorize what is not a security, and we'll go into that next. But for now, here's a list of what, according to this USA, are securities. Stocks, including treasury stock, that's stock that's been bought back by the company. Bonds, including debentures. Debentures are unsecured bonds. Notes, those are short-term debt securities. Limited partnership interests, partnership in any profit-sharing agreement. Certificate of interest in a business trust. Collateral trust certificate. Transferable share, investment contract, voting trust certificate, certificate of deposit for an equity security such as an ADR or GDR, participation certificate, also known as CMO, futures contract on a security, option on a security, index of securities, option on a foreign currency, option on commodity futures contracts, options on any security, warrants, that is right to purchase shares at an agreed upon price in the future, preemptive rights, those are rights to maintain proportionate ownership in the event a company issues more shares, variable annuities, mutual funds, ETFs, REITs, RELPs, DPPs, whiskey warehouse receipts, that's my favorite, that's in the Uniform Securities Act, multi-level distributor arrangement, and merchandise marketing programs. All securities, according to the Uniform Securities Act. The following are not considered to be securities, at least according to the Uniform Securities Act. For the exam, you should memorize this list. Fixed annuities, including equity indexed annuities, insurance products with a guaranteed payment, including whole life, term life, universal life, and endowment policies. Commodities, such as gold, oil, cattle, corn. Commodity futures contracts. However, options on commodity futures contracts, or any option, are considered to be securities. Collectibles, such as antiques, art, and fine real estate used as a personal residence, and a group retirement plan, such as a 401k or an IRA, is not a security. However, an individual interest in such a plan is a security. Is it a security according to the Uniform Securities Act? Stradivarius violin. No, it is not a security, it's a collectible. Canadian government bond. Yes, any bond is a security according to the Uniform Securities Act. Participation certificate, or CMO, collateralized mortgage obligation. Yes, participation certificates and CMOs are securities. Bond issued by a local school district. Yes, any bond is a security, even a municipal bond. Variable annuity. Yes, variable annuities and any kind of variable life insurance product is considered to be a security. The key word is variable. If it was fixed, a fixed annuity would not be a security, but variable means it is. Oil well on grandma's ranch. No. Oil well on grandma's ranch, not a security. Term life insurance policy. No. Term life is a fixed life insurance product. it is not considered to be a security. Interest in a collection of old musical instruments, including a Stradivarius violin. Yes, or probably yes. An interest in a collection of valuable items, such as musical instruments and a Stradivarius violin, would probably be a security, according to the Uniform Securities Act. American depository receipt, that means shares of an international company. Yes, ADRs, or American depository receipts, are considered to be securities. Option to buy oil well owned by grandma. Options are usually considered to be securities, so this is probably a security. And finally, equity indexed annuities. No. And here's where the regulators have made a clear decision. Equity indexed annuities have a variable component, but regulators have decided that these are not, at least now, considered securities for the sake of the law and the exam. John Doe sells bogus term life policies to patients at a nursing home. Has John violated securities laws? Probably not. It appears that if he just sold term life policies, just plain old insurance, he may have committed insurance fraud, but not securities law violation. So the answer is no. John Doe is double trouble, though, and he sells bogus stock to the same patients at the nursing home. Has John violated securities laws? Can the administrator charge John Doe with securities fraud? So 2 questions. And the answer to the first is yes, it appears John Doe has committed securities fraud, or it's likely that he did. However, and here's the trick, the administrator is not able to prosecute securities fraud. That is not within the realm of what the administrator is permitted to do. The administrator has to refer the case usually to the state attorney general for prosecution. However, the administrator has a bunch of tricks up his or her sleeve, things that they can do to enforce securities laws and regulations. These include issuing cease and desist orders, revoking registration, suspending registration, denying registration, forcing rescission, that means repayment, and imposing administrative fees. These are all things that the administrator can do, but the administrator cannot prosecute securities fraud. That's something they have to do to refer to the Attorney General. Finally, when you're trying to memorize or remember what is and is not a security, it's easier to try to remember or memorize the shorter not a security list than memorize the big long yes, it is a security. Non-exempt security means that a security must be registered under the Uniform Securities Act. It is unlawful to sell securities unless the securities have been registered under the Uniform Securities Act, the securities or the transaction has been exempted from registration, or it is a federal covered security, and that means it must be registered with the SEC. The following securities are exempt securities from state regulation, and under the USA, they do not need to be registered at the state level. U.S. government and government agency securities, such as Treasuries, mortgage-backed securities, CMOs, Fannie Mae, Freddie Mac, Sallie Mae. Municipal securities, except in the same state that they were issued. Depository securities, such as bank CDs, savings and loan and credit union securities, nonprofit securities, Canadian national government and municipal government securities, foreign national government securities, but not foreign municipal or corporate bonds. Investment grade commercial paper or promissory notes, that is corporate debt that matures in no more than 270 days with a minimum value of $50,000. And finally, federal covered securities. Exempt securities are still subject to state anti-fraud laws. So the administrator still has jurisdiction when it comes to fraud with regard to exempt securities. What is a federal covered security? Well, a federal covered security is a security that is exempt from state registration, but that means it must be registered at the federal level. Thus, it is federal covered. It is a category of security created by the National Securities Markets Improvement Act. Most popular securities are federal covered. That includes all exchange-listed securities, anything traded on the New York Stock Exchange or NASDAQ, securities registered under the Investment Company Act of 1940, such as mutual funds, ETFs, closed-end funds, UITs. These are all federally covered. It also includes certain exempt transactions, notably Reg D private placements. These are unregistered securities sold to accredited investors. These are also federally covered. It is important to note that even though they are exempt from state registration, federal covered securities are still subject to state anti-fraud laws and thus still subject to the state administrator's jurisdiction when it comes to fraud. What about municipal securities? Well, states are not allowed to require registration of other states' municipal securities. However, because states can require registration in their own state, that means that municipal securities are not considered federally covered. So what that means is municipal securities are exempt in every state but their own. Question: are all securities registered with the SEC considered federally covered securities? The answer is no. There are thousands of small issues, so-called OTCBB or over-the-counter bulletin board or pink sheet securities, that may require registration with the SEC, but they are not considered federally covered securities. Question: can a non-exempt security be sold if it has not been registered in a state and it is not federal covered? And the answer is normally no. It cannot be sold. A non-exempt security cannot be sold since a non-exempt security must be registered in a state. However, it could be sold if the unregistered security is sold in an exempt transaction. And there's more about that to come later. Question: what federal act created the category of federal covered security? And the answer is the National Securities Markets Improvement Act, or NSMIA. That was done in 1996, but you should remember the National Securities Markets Improvement Act created the category of federal covered security. Finally, are non-securities, for example, real estate, fixed annuities, commodities, collectibles, are non-securities covered by the Uniform Securities Act's anti-fraud provisions, the USA's anti-fraud provisions. So are non-securities covered by that? And the other question is, are exempt securities, that means federal covered or municipal securities, are exempt securities covered by the USA's anti-fraud provisions? So a related question. The answer, non-securities, that means things that are not securities, are not covered under the Uniform Securities Act's anti-fraud provisions, which means that the administrator, the state administrator, has no jurisdiction when it comes to fraud if it's not securities related. So real estate would be done by somebody else, probably by the Attorney General. Fixed annuities, fixed annuities by the insurance regulators. Anything that is not a security is not covered by the anti-fraud provisions of the Uniform Securities Act. However, exempt securities, such as federal covered and municipal, they are covered by the Uniform Securities Act's anti-fraud provisions. Even though they're exempt, they're still securities, and so they still fall within the jurisdiction of the state securities administrator when it comes to fraud. There are 3 ways of registering a security at the state level. The first is called registration by notice filing, and this is simply a notice filing, literally, with the state of the federal documents. It's the easiest form of state registration, and it's only available for securities that are federally covered. The requirements include that the issuer must have been in business for at least 3 years, and there cannot have been any default on paying any principal, interest, or dividends within the last 3 years. So it needs to be a solid going concern for it to be able to do this. All they need to do is notify the state administrator, and the state will collect its fee. The state administrator can request extra documents as part of the notice filing. Those documents could be the SEC filing documents, any amendments to the initial federal registration statement, an assessment of the value of the security, and consent to service of process. The second way of registering a security at the state level is by coordination. In coordination, it's for securities that are sold in multiple states at the same time, and so the issuer registers their security first with the SEC at the federal level, and then coordinates their state filings with their SEC filing. The following items are needed to register by coordination: a consent to service of process, which is done with Form U2, 3 copies of the prospectus, any amendments filed with the SEC, copy of the Articles of Incorporation, the bylaws currently in effect, copy of any agreements among underwriters, copy of the indenture, and of course, any fees required by the state. For the most part, the registration date at the state level is the same date as at the federal level, unless certain qualifications are not met. And registration by coordination is the most common method of state registration. The third way of registering a security at the state level is by qualification. Qualification is the most rigorous kind of registration. It is used only at the state level. There's a long list of necessary requirements in the text. You should review them. The administrator can request other info. Registration by qualification becomes effective when the state administrator says so, unlike registration by coordination, which becomes effective when the SEC accepts registration documents. Okay, now some registration questions. Number 1, XYZ is issuing securities that will be listed on the NASDAQ exchange. XYZ wishes to sell securities in the state of New York. What type of securities registration, if any, would XYZ use? And the answer is notice filing, because it's a federal covered security. It's listed on the NASDAQ. It would be registered at the state level by doing a notice filing. Question 2. BLT is issuing securities that will not be listed on an exchange but will be offered in multiple states. What type of securities registration, if any, would BLT use? And the answer is registration by coordination. That is, they would be coordinating their state filing with the SEC, the federal filing that they're doing. Question 3. ACE Insurance is about to launch a series of equity indexed annuities which will be sold across the country. What type of securities registration, if any, would ACE use? And the answer, equity indexed annuities are not considered to be securities, so they would not need to be registered with the securities administrators. Okay, now we're going to talk about transactions. A couple of different kinds of transactions. First of all, issuer transaction. An issuer transaction is when an issuer raises money by selling securities to investors. And when this happens, the proceeds, the money from the sale, go to the issuer. It's called a primary offering, and that means it's first. It comes from the issuer, as opposed to a secondary offering, which we'll talk about later, and that's between parties that are not the issuer. Examples of issuer transactions include when a mutual fund sells securities to investors. Every time investors buy mutual fund shares, new shares are issued, and the funds, the money, the proceeds go to the mutual fund. So those are issuer transactions. Also, IPOs, initial public offerings, that's when there's a first-time securities sale from an issuer, and those are sold to the public, and the money, the proceeds, goes to the issuer. So IPOs are another issuer transaction. And then finally, when the issuer repurchases their own securities on the market, this happens all the time, stock buybacks. The stocks go back into the treasury of the issuer, but those transactions are issuer transactions, considered to be issuer transactions. If the exam mentions an underwriter or the primary market, assume that it is an issuer transaction. Non-issuer transactions are transactions that occur between parties other than the issuer, and this is taking place in what's called the secondary market. So the money and the securities exchange hands between parties that are not the issuer. Examples of non-issuer transactions include John buys 100 shares of ABC Company on the NASDAQ exchange. A mutual fund buys 1,000 shares of Apple for its mutual fund. And the Oregon State Public Retirement Fund sells a previously issued bond out of its inventory to Fidelity. All three of these are examples of non-issuer transactions. State securities registration begins on the effective date, and it lasts for up to 1 year from the effective date or until securities have been sold, whichever comes last. The administrator sets the filing fees. The administrator may require the proceeds of the sale to be held in escrow. The administrator may require a specific subscription form for the sale of the securities. The issuer may use a previous registration statement if that statement was filed within the past 5 years and it is still accurate. The administrator may require the issuer to make progress reports on the sale of the securities, and the administrator may require the issuer to file financial statements on a quarterly basis, but not more frequently than that. Okay, some questions. In which type of transaction does the issuer receive funds? Primary or secondary? The answer is primary. Issuers receive the funds in primary transactions or issuer transactions. Number two, in a non-issuer transaction, does the issuer care about price and liquidity? Yes, most issuers want the price of their stock or their security to be higher rather than lower, and they would like a liquid market for their company's shares. The reasons are several. They may want to issue more shares in the future, so the more in demand the available shares are, the better. Also, insiders of the company will want their shares to be worth more and be in more demand. Finally, employees of the company may have stock options, so the stronger the market for the shares, the better. Number three, how frequently may an administrator require securities registrant to file financial statements? And the most frequently that an administrator may require financial statements to be filed is quarterly, every 3 months. Number four, state securities registration is effective for how long? Securities registration begins on the effective date and lasts for up to 1 year from the effective date or until the securities have been sold, whichever comes last. So I've mentioned a couple of times without explaining something called exempt transactions, and I'm going to try to go into that in a little detail right now. So remember, all securities must be registered unless they are exempt or unless they are sold in what's called an exempt transaction. There are many types of exempt transactions. We list them in the text, but here are a few of the major types of exempt transactions. First of all, isolated non-issuer transactions. Those are transactions between two private parties, and even if it is handled by a broker-dealer, it doesn't matter, as long as these transactions do not occur regularly. Second, unsolicited brokerage transactions. This is the most common type of exempt transaction. So whenever an investor purchases shares or sells shares through their broker-dealer, that's an unsolicited brokerage transaction. Underwriter transactions. Those are transactions when an issuer sells its shares to an underwriter, to an investment bank. Bankruptcy, guardian, or conservator transactions, also exempt. Institutional investor transactions. Those are managers of big money, even bigger than accredited investors. Those are exempt transactions. Finally, private placement transactions, and there's a lot of those now. Those are offers that are sold to up to 10 investors. When making a securities filing, the issuer is called the registrant. On the application is the following information: the amount of securities to be issued in the states in which the securities will be offered, any adverse orders concerning the offering from the SEC or any other regulatory authorities, the anticipated effective date, the anticipated use of the proceeds. What is not on the application is any rating of the security. What else is included in an application for securities registration? Well, filing fees, of course. Very important to the states. They are usually based on the size of the offering. There are also sometimes ongoing reports that need to be filed, but again, they cannot be filed more often than quarterly. Unlike the registration of persons, so agents or IARs, where December 31 is the key date when registration has to be renewed, the registration of securities is good for 1 year from the effective date. And these dates and the differences between persons and securities, they are something you must remember for the exam. A municipality issues municipal securities. Does the municipality need to register these securities at the federal or state level? And the answer is no, they don't need to register them at the federal level. Municipal securities are exempt from federal registration requirements. Also, the municipal securities are exempt in all the states except the one that the security was issued in. So it might need to be, the securities might need to be registered in the state of issuance, but that would be the only one. XYZ is listed on the New York Stock Exchange. Does it need to register the securities in the states where they will be sold? Well, it needs to do a notice filing because this is a federal covered security. All XYZ needs to do is do a notice filing, and that's it. ABCD is a corporation that is issuing new securities. They'll be quoted on the OTC bulletin board. Will these securities need to be registered in the states where they will be sold? Yes, they will need to be registered, but if it's going to be sold, if the shares are going to be sold in multiple states, then they would probably register at the federal level and then register by coordination at the state level. However, if these shares were exchange listed on a national exchange, then they could register via a notice filing to the states. However, more likely that they would be doing a federal registration and then register by coordination at the state level.